All right, if you're a litigator in the Philippines, there's one procedural rule you've absolutely got to know inside and out. Today, we're diving deep into that rule. Rule 41, the one that governs appeals from the regional trial courts. So picture this. You've just received a judgment from the RTC, and it's not in your favor. Ugh. The clock starts ticking like immediately. The pressure is on. But your next move isn't about panicking. It's about being precise. The path forward is laid out by a strict set of rules, and believe me, one tiny misstep can be absolutely fatal to your client's case. And that path is Rule 41. You should think of it as your procedural GPS for getting to the appellate courts. It tells you exactly where you can go, how you need to get there, and what happens if you take a wrong turn. For any litigator, mastering this rule isn't just a nice-to-have, it's absolutely essential.
So in this explainer, we're going to break it all down. We'll kick things off with the most critical question: can you even appeal in the first place? Then, we'll map out the 3 different ways to appeal, we'll get into the details of the most common one, point out the traps that can get your appeal dismissed, and then wrap it all up with a key takeaway.
Okay, before you even dream of drafting a notice of appeal, you have to answer this one fundamental question. Is the order you're holding in your hand actually appealable? Getting this wrong is a fatal error, so let's make sure we get it right.
Section 1 of Rule 41 gives us the bedrock principle. An appeal is only available from a judgment or a final order. So what's a final order? Well, it's one that completely ends the conversation on the merits of the case. It leaves nothing more for the trial court to do. You see, the whole point is to prevent endless appeals over every little thing before the main case is even decided. And this really shows you the great divide in appellate practice. On one side, you've got your final judgments and orders. Those are your golden tickets to an appeal. But on the other side, you have what are called interlocutory orders. These just resolve small, incidental things but don't end the case. And then there's a specific list of other orders that are explicitly 100% not appealable. Now, the rules are very, very clear about what you cannot appeal. This list from Section 1 is basically your big red stop sign. An order denying your motion for reconsideration? Nope, can't appeal. An interlocutory order? No way. An order of execution? You guessed it, no ordinary appeal. Seriously, burn this list into your brain. It will save you from filing a completely useless pleading.
So, if that Rule 41 door is slammed shut, is it game over? Not always. The rules actually provide an escape hatch for these non-appealable orders. Your remedy isn't to argue the merits through an appeal, but to file a petition for certiorari under Rule 65. This is a totally different strategy. Here, you're arguing that the judge acted with grave abuse of discretion, basically that the decision was just arbitrary or way outside the bounds of the law.
Okay, so let's assume you've got that final appealable order. You're good to go, right? Well, now comes your next critical decision, choosing the correct mode of appeal. Section 2 lays out 3 distinct paths, and picking the wrong one is just as fatal as trying to appeal a non-appealable order. This table is your cheat sheet for sure. First, you have the ordinary appeal under Rule 41. This is for cases that started in the RTC, what we call its original jurisdiction. This appeal goes right to the Court of Appeals. Second, what if the RTC was hearing an appeal from a lower court, like a municipal trial court? Well, then it's acting in its appellate capacity. In that situation, your next move is a petition for review to the CA under Rule 42. And finally, if your entire case hinges only on questions of law, no factual disputes at all, you can take the express lane directly to the Supreme Court using a petition for review on certiorari under Rule 45.
All right, for the rest of this explainer, we're going to focus on the real workhorse of the appellate system, the ordinary appeal under Rule 41. Let's walk through the exact steps you need to follow to get your client's case properly before the Court of Appeals.
The most important number in this entire process is 15. Section 3 gives you a strict 15-day period from the moment you receive that final order to file your appeal. The main exception is if a record on appeal is required, like in special proceedings, then you get 30 days. But for most cases, it's 15 days, and this period is non-extendable, full stop.
The procedure itself is pretty straightforward. First, you file the notice of appeal with the trial court, and, this is huge, you pay the docket fees, all within that 15-day period. The moment that's done, the appeal is officially perfected. At that point, the trial court loses its power over the case, it loses jurisdiction, and then the clerk of court just has to pack up the records and ship them off to the Court of Appeals.
And what exactly do you put in that notice of appeal? Well, Section 5 keeps it simple. You have to identify the parties, Point to the specific judgment you're appealing. Name the court you're appealing to, the Court of Appeals. And this is critical. You have to list the material dates, the date you got the decision, and the date you filed any motion for reconsideration. Why? To prove to the court that your appeal is on time.
So, we've seen the right way to do it, but where do people most often go wrong? Let's talk about the common pitfalls. These are the heartbreakingly simple mistakes that can get a totally valid appeal dismissed before it's even heard.
This is a question no lawyer ever wants to ask, and the answer is almost always a failure to strictly, and I mean strictly, follow the procedural rules we've just been talking about. The appellate courts, well, they don't have a lot of sympathy for these kinds of errors.
So let's list the 4 big dismissal traps. Number 1, filing late. Miss that 15-day deadline, and you're done. Number 2, appealing in non-appealable order. Your appeal will get thrown out and you've just wasted precious time you could have used to file a Rule 65 petition. 3, using the wrong mode. Filing an ordinary appeal when it should have been a petition for review is a major jurisdictional error. And 4, failure to pay the docket fees on time. You got to remember, paying the fees is mandatory and jurisdictional.
Okay, we've covered a ton of ground, from figuring out appealable orders to navigating the procedure and avoiding those fatal mistakes. Let's boil it all down into one simple, powerful takeaway. If you remember nothing else from this, remember this. Rule 41 is about 3 things. What can you appeal? Only final orders. How do you appeal? By picking the correct one of the 3 modes. And when must you appeal? Within 15 days. What, how, and when. Simple as that.
And that really is the bottom line. Successful appellate practice isn't just about brilliant legal arguments. It's built on a foundation of procedural perfection. So the question you have to ask yourself every single time is this: did I choose the right remedy for the right order at the right time? Answering yes to all 3 is your first and most important step toward victory.